Good afternoon, everyone, and welcome to this IAMOnline webinar for JISC in partnership with JISC. It's moving towards GDPR online briefing. Thank you very much for attending today. My name's Edward from the JISC training team here in Harwell in Oxfordshire in England, and Andrew Cormack is with me, and he's going to be presenting the session. He's our Chief Regulatory Advisor. So without further ado, as soon as we've got to the start time, I will hand over to Andrew. Thank you.
Okay, thanks Edward. I get a thumbs up to say my microphone's working too. Excellent. Yeah, welcome to everybody. I see we're certainly covering the Atlantic shores quite well. Spotted people from North America as well as from the continent, so we're kind of in the middle here for a change. Yeah, I spend about 45 minutes, I hope, talking about the new data protection laws that are coming in Europe next year, hopefully giving some positive ideas for how to implement them, clues for what to look for, but I'm afraid also some caveats that perfect compliance probably isn't even defined, let alone achievable yet. So, General Data Protection Regulation, which I will henceforth refer to as GDPR. I should introduce myself, shouldn't I? Andrew Cormack. I fly under this banner of Chief Regulatory Advisor for JISC Technologies. Originally started working for what was then Janet, which is the operator of the UK's National Research and Education Network, as head of the incident response team back in 1999. So my background's technical. Gradually then moved over into more policy and regulatory and legal stuff. Which is what I've been doing for about the last 10 years, essentially trying to keep an eye on both the law and the technologies and the services that we offer as a National Research and Education Network, trying to work out how those can be brought, those can be introduced to each other, let's say, without too many loud bangs, bumps and painful experiences. So I'm generally looking for ways that technologies actually support what the law wants to do, particularly in this area in terms of privacy and data protection. Apologies, by the way, to those to the west of me. I will probably say privacy throughout, but I'm hoping you're used to translating that to privacy for North American ears. So, outline of the session, a look at what new legislation there is, and who it covers, what it covers. Then the main changes in approach, because in Europe we've had data protection legislation since 1995, so I'm getting my years right. So this isn't a completely new invention. It does build on what there was, or what there is as of today. But there are some changes needed in the way we think about our processing of personal data. Then moving on to some, I hope, practical stuff, largely actually based on what we are doing within JISC, as well as what we're recommending to our customers and to wider partners. So we are eating our own dog food. That also means that the how to approach it section isn't complete because we're not at the 25th of May next year yet. So towards the end of our project plan, we haven't actually worked out those bits. We know what we're going to do, but the overall thinking, or the detailed thinking, we probably haven't done yet. And then finishing off with some examples that are commonly come up when we're talking about research and education networks and the sorts of services that we run over them. And there should be some time at the end for any questions. If there are any points that immediately come up from a slide that you think, well, I'm not going to understand the next slide if I don't get this one, Andrew's forgotten to explain something or use an acronym or something, do pop those in the question panel. Questions or chat? Chat. Put those in chat and I'll try and spot them and deal with them as we go through. So, what the GDPR is, it's a regulation created by the European Union. If you want to find it, that's its unique reference number. That means because it's a regulation, unlike the current data protection, which is a directive, regulations apply directly to every organisation in Europe. So a directive is an instruction to governments to say, go and legislate something that has this effect. A regulation, there's no need for, or there should be no need for countries to do anything. This automatically becomes law, directly usable. Interesting feature of the GDPR is it also claims to apply to any organisation that is either providing services or collecting data for people in Europe. The short form of Europeans here tends to be a bit misleading. It is actually your physical location that matters. If you're in Europe, no matter where you're a citizen of, you are covered by this legislation while you're in Europe. So if you're providing services or collecting data about Europe here, about people in Europe, then this is going to apply. As I said, it replaces the current 1995 Data Protection Directive. It's about 3 times longer. Partly that's because it's a regulation, so it has to have more detail, so it can be directly usable. But it does cover more, it says more about some of the activities that we want to do, and it is a big chunk of reading. And it is already law. It was passed into law on, I think, the 26th of May last year, 2016, but there was a 2-year implementation period allowed, so it actually comes into force on the 25th of May 2018. So the expectation is that you will be doing what the regulation says from 25th of May next year. That was recognised at the time as a challenging target. It's been made more challenging to my mind by the length of time it has taken regulators to actually provide us with usable guidance on how to do this, and as we'll come to in a minute, there are some significant things are still missing and will be missing for several months yet. That's what it is. What it isn't is finished. I said regulation ought to be directly applicable without member states doing things. This is actually a weird hybrid because there are about 50 areas where it says member states should go and do something. So that looks kind of like an old-fashioned directive, which creates problems because the member states may not have got round to doing it yet. The UK bill to implement the bits of the regulation that we are required to do nationally is being debated in Parliament right now. I think Germany have finished their legislative process. As far as I know, they're the only country that has. So in areas like, scarily, how to use personal data in research, firstly, it's down to national governments, parliaments to decide. So there won't be a single European law on those. And certainly in the UK, we don't actually know what the research provisions are going to look like yet. There is a draft, but that's subject to debate in Parliament, and who knows what the outcome will be. We hope it will be similar, and our data protection regulator has said she hopes it will be similar to what we have under the current system, but that is up to members of Parliament to decide. In addition to that, even the areas which are set as a standard, European regulators then have to get together and produce guidance on things like what valid consent looks like. And they've been, to my mind, very slow in producing that. The consent guidance we don't even have in draft yet. They just last week published draft guidance on breach notification and profiling and automated decisions. The breach notification one I like, the automated decision one I think is awful and doesn't actually reflect what the text of the law says. We will be feeding that back. I'm very much hoping there will be a different version of that guidance that comes out, but I'm not expecting that this year. So we may have 2-3 months at best to implement the detail of these sorts of things. Having said that, there is quite a lot of high-level stuff that you can and should do to make sure that your diaries are completely clear for implementing the detail as and when it becomes available. In addition to the GDPR, oh yeah, sorry, the list of guidance doesn't even include cloud, which is probably one of the most challenging areas, how cloud computing actually fits into this whole legislative framework. As far as I know, no regulator is planning to pronounce on that. Then, in addition to the GDPR itself, we've got a draft e-privacy regulation, which covers not just networks and communication systems, but also covers cookies. They've realized it covers security patches on end devices. I think most people are now regretting the discovery that it covers security patches, but there was concern about software being installed on end user machines, and the way it's been drafted, that covers patches. Also covers things like location tracking, so tracking you using your Wi-Fi or Bluetooth signals. That was only published in draft this January. The European Commission believed that it would be possible to bring that into force again on the same day, 25th of May next year. The European Parliament, I think last week, agreed its negotiating position. They have to then agree a final text with the Council of Ministers, so the individual ministers of state from each country, and the Council of Ministers haven't got as far as their position yet. So that negotiation will be going on, I suspect, well beyond next May. So I'm planning for uncertainty, things to change unexpectedly, even contradictory statements in the law. The automated processing guidance, as far as I can see, flatly contradicts the guidance on breach notification, for example. That's in two guidance drafts published on the same day. So this is not a nice, clean situation where we know what the law is and we know what we have to do. We just need to get on with it. There's going to need to be a fair bit of improvisation and flexibility. So, can I just say, oh, this doesn't apply to me and leave it? That would be wonderful, but unlikely to work. This covers anybody processing, any organization, any individual processing personal data, and that includes collecting, storing, deleting. Personal data very, very widely defined, so MAC addresses, IP addresses, RFID tags, etc. I'd plan for all of those to be treated as personal data. There may be some edge cases where they're not. The example that's sometimes given is the open Wi-Fi in a cyber cafe. Is that IP address really personal data when nobody knows who the individuals using it are? But then governments are increasingly looking disapprovingly at open Wi-Fi, which doesn't allow individuals to be identified. So my safety first approach is to say anything where one record is one user, I want to have a plan at least for when that is declared to be personal data, because I suspect it will be. The mention of Breyer there is a European Court of Justice case which actually backdated this idea that dynamic IP addresses were personal data to apply under the current law as well. So this technically isn't new for the regulation. It's something we need to be scratching our heads over already. And then, as if that wasn't wide enough, the privacy regulation actually covers all data relating to communications, even the stuff that isn't personal data. So if you're processing headers of any kind, content of any kind, location of digitally connected devices, if you're pushing updates to digitally connected devices, you're going to be covered by the e-privacy regulation, even if not by the GDPR. So I'm guessing nobody will have left the webinar because, hey, this doesn't apply to me. So we need to work out what to do. Also, bear in mind, some people on the list may well be writing software that others will then, or software systems, that others will then use to process personal data. If you're only developing software, you may not be covered directly, but if you want your software to be usable, the people who are going to use it to process personal data will want to know what compliance features you've designed in. Especially, and this is an interesting one, the kinds of data or processing it's not designed for. So if you've designed your security measures to be appropriate for processing data about stars, then make very clear that this system isn't designed and its security measures aren't adequate for processing health data. Now, it's quite easy to say they're both research data, but actually the security measures and arrangements around them should be very different, because the astrophysicists can't afford to pay for health levels of protection, and the health people certainly don't want their data to be as easily available as astrophysics data can be. The e-privacy regulation, say Commission draft January this year. Did I miss anything? Oh, it only covered public network operators, but Wi-Fi and Bluetooth tracking, browsers, cookies, say software updates. And its principles are that these sorts of systems, these sorts of data, you can only process if it's necessary for the service you're providing, if it's necessary for security, or if you've got consent from the user. And as we'll come on to later, the GDPR definition of consent is much tighter, much harder to achieve than any European level requirement has been in the past. Then the European data protection regulators, who don't formally have a role in the legislative process, but they felt they wanted to comment on this. Back in April, they published opinions that said, well, why just publicly available networks? Why not? And their quotes were hospitals, hotels, and universities, because those are networks that are made available to patients, visitors, and students. And those should have a right to privacy too. And they also added anyone else processing the same data. And that gets very interesting for people doing network research, because that might well suddenly be covered even when it wasn't in the past. The Parliament and Council, the two bodies that do have a role in the legislative process, and those dates are a little out of date because they both take long summer holidays, so update that to September, October 2017. The Council has said that the ambition of getting this in place by next May is unrealistic, and I quote, and in European diplomatic speak, that's pretty strong. And the Parliament then said, hey, we'd like to amend it. In fact, we'd like to amend it so much that here are 400 pages of amendments. And there may actually be more than 400. I found 400, but it's in a load of separate PDFs. So I really don't see this happening by next May. So what are the main changes? My kind of short elevator pitch is that under the directive, the current data protection law, we were asked to think about what personal data are we processing. So we went off and looked for personal data on disks and on memory sticks and stuff, and we found it, and we went, great, we understand it, we're done. Under GDPR, I think you need to take a broader view and say not just what personal data are we processing, but why. What's the purpose of us having this data? Why are we collecting it? How are we collecting it? How are we processing it? And indeed, how and when are we deleting it? Those are all much more clearly a focus of the GDPR. So in a bit more detail, some of the headlines that have been used by the legislators over this, and we'll look at each of these in a bit of detail: accountability, data protection by design, consent, user rights, and security. So, accountability, everybody agrees that there is a strong accountability principle in the GDPR, and I've not seen any two documents that agree on what that means. So I think it's something around needing to both understand and document what personal data you're processing, why you're processing it, where, how long for, who may obtain it. So the full information life cycle, not just an asset register. We need to look at risks. The accountability is certainly a shift from the Data Protection Directive, where the idea was that you were required to inform individuals what data you were processing, and then it was kind of up to the individuals whether they stayed with you or walked away. And if they stayed with you, pretty much you were done, you were okay. Accountability moves that to expecting data controllers, the organizations that decide why and how personal data are processed, to justify that processing, to think about it, to make a convincing case that this is necessary and is appropriately protected. So organizations now have to look at what are the risks, not to the organization but to the individual, resulting from that processing. There's also some new requirements. How many depends on which country you're in, because there was a fair bit of variation in national implementations of the existing directive in this area. And once you know why you're processing, one of the things that comes out of that is there are different bases in law in the regulation. They were in the directive as well, as to why you're processing personal data. Come on to them in a bit. But the important thing at this stage is that the legal basis you use affect what information you have to give the individual, what your obligations are, and what rights the individual has. So in looking at the processing we do within JISC, working out the legal basis is almost the key to everything else. Once you've got that, it's not quite handle cranking to get all the rest to fall out, but it's not far off it. And there is quite a lot of handle cranking. But from the legal basis, from the information lifecycle information, you know pretty much all you need to do the implementation. You just then need to work out what the actual requirements for implementing it are. One of the ideas which tends to get filed under accountability is that high-risk organizations are needed to formally appoint a data protection officer, which is somebody who is independent both of kind of management control and pressure, and also independent of the decisions that the organization is making. So the data protection officer can't be the person who is deciding what personal data gets processed and how. They need to be independent. I visualize it both as independent upwards and downwards. The types of organizations, two types of organizations are actually required to have a DPO. There's encouragement for others to set up this kind of this position. The ones that have to, public authorities, which sadly is undefined in the GDPR, but I've been helped by a law professor to dig back and find where the concept seems to have first emerged. And it's something about bodies that have special powers that aren't just normal data processors. So there's some legal provision that says because you are the tax office, you can process personal data to detect tax fraud. So that kind of thing. Or organizations whose core activities involve large-scale monitoring or or processing of sensitive personal data of individuals. So that's health, religion, race, sexual orientation and practice, and a couple of trade union membership, and a couple of other things that I will remember at some point. Certainly in the UK, my impression is that most universities have concluded that they fall within that second category, that the process of looking at a student for 3 years and deciding what degree they get at the end of it, 3 years, 4 years, is large-scale monitoring of individuals and is sufficiently high risk that they ought to have a DPO. Don't know how that's working out in other countries. Also, somewhat related to accountability, there's this idea, I've been a security person for 20 years, I've been saying security can't be added on, it has to be designed in. Now I have to get out all of those slides and data protection can't be added on, it has to be designed in. So they're looking for developments of new processes, new systems, to show that you've considered how you're going to do data protection. And they mention things like, are you minimizing the personal data you processed? Are you looking at, can you do this with anonymized data? Useful thing for federated access management. I see quite a few people in that area on the list down to D's anyway, which is how big my screen is. Pseudonyms are now seen explicitly recognized as a privacy protecting measure. So that's identifiers that don't identify. So things where you need an additional key to find out who the owner of that identity actually is. The data protection by default idea is that if there are any options in your software, your process, your app or whatever, they should default to privacy protecting. You can provide users with the ability to give away some privacy, but it has to be in that direction. You can't provide a privacy invasive system and say, hey, but the user could turn off those features. You have to have them off by default. Again, at the top end, at the high risk end, there's an idea of data protection impact assessments, large-scale processing, high-risk processing, novel technologies where I suspect we might fall into this idea. They seem to be heading, the DPIAs used to be something quite different, but they seem to be heading to the idea that it's kind of a risk assessment. So you identify risks, you identify how you're going to mitigate them, and you assess the residual risk after you've mitigated them. The key difference from risk management is the risk you're looking at is the risk to the individual, not the risk to the organization. So normal risk management, you look at how risky is this for the organization. DPIA, you should be looking at how risky it is to individuals. This is one area where the regulators have just finalized their guidance and published it. Where are we? We're still in October, earlier this month. Yes, nobody's far enough away to be on a different date, so today, this month. If you can't mitigate risks, if your DPIA identifies high risks that you can't get rid of, then you need to get approval from your national data protection authority. I suspect that's mostly thinking about government projects. We've got in the UK, we've got a lot of automated number plate recognition systems. I suspect those will need DPIA approval in future. National identity cards, things like that. I think it's those kinds of things, possibly large-scale use of health data. And although the regulation actually says this is for new systems, the regulators have been quite clear that they expect existing systems to be brought into it in due course. The draft actually had a date of 2021, but in the final version that's gone away. But that sort of timescale. Consent. A lot of variation between countries on how this was done, indeed between continents, on how this has been done in the past. GDPR, as far as I can see, is designed to make consent hard to obtain. So to encourage you, in some cases force you, to look at the other possible justifications. So consent has to be has to be free, and they mention things like employer-employee relationship as likely to involve too much imbalance of power for consent to be freely given. Has to be informed, so the individual needs to know before they consent what are the consequences of consenting, what are the consequences of not consenting. Big change, it has to be a positive action. You can no longer put up a pre-ticked box and say the user didn't change it, therefore they've consented. Has to be some sort of positive action. Maybe not, doesn't have to be explicitly a tick box of I consent, but it certainly has to be something that you can argue the user understood and agreed to what's the consequences of their clicking on this link, entering this building, whatever were. And one that I think is going to be interesting to see how strict the regulators are on it, statement that consent must be revocable as easily as it is given and at any time. So that one could be quite interesting given some of the practices that have been, not so much in our sector, but certainly in commercial organisations where they assert consent and you then need to, for example, if you're lucky, send a pay-for text to remove yourself from a mailing list. Whether that's going to be seen as easy as it was to get on the list, I don't know. A couple of things specifically pulled out: must not be a condition of service. So if you are saying we need to process this data to give you access to that service, the only data you can say that is a condition is the data that's needed to use the service. You can't, as the train I was on this morning did, say you can connect to the Wi-Fi as long as you give consent to receiving marketing emails. So that won't be valid. I'm hoping that enough of us are giving invalid emails to those that it would become not worthwhile by next May anyway, but it's quite clear in the regulation that's not allowed, and not under compulsion, where there's an imbalance of power between the individual and the organisation seeking consent. In addition, you need to keep records of consent, who consented, how, when, to what. What did your privacy notice look like at the moment that person gave consent? So that's hard. It's designed to be hard. There was a fair bit of use of the phrase reduce overuse of consent when this was being introduced. So it is explicitly intended to be hard. That looks by Dave's question. One of the ideas is if there is another option, Dave, but I think what they're thinking about is providing an option of a service that is paid for and an option of the service that is funded by data. And there they might consider that your consent to the data being used was valid because you didn't have to. I can't think of a service where you could provide an equivalent service by non-electronic means. If you could, then that might be an argument that there has been there's no what's the phrase that's used? It's not disbenefit. Essentially, there must be no disadvantage to the individual from choosing the other one. So my conclusion from that is we're going to have to look at the other 5 legal bases if we haven't been looking at them already. Okay, so that's not the next slide, that's in a couple more. Whether this is new, not sure, probably depends which country you're in. In the UK, this doesn't feel terribly new, but there are explicit rights of an individual to obtain information about what you're doing. They have information right largely exists at the moment, maybe some change in detail. Subject access, you have the right, subject to 1 or 2 exceptions, to obtain copies of the data that are being processed about you. And here there's a little bit more metadata than the existing subject access request. But again, subject access processes should already exist. Data portability. I'm not even clear this is a data protection right. It's the explanation of why it was needed was to allow people to move from one social network to another. So we create a right that applies to every data controller, every organization processing personal data. I think for many organizations it will be possible to treat this as a subject access request, and in fact it's limited. It's not a full subject access request. This is one of the things that depends on your legal basis. So if you're using consent, or if you're saying that processing is necessary for the purposes of contract, this one applies. Other bases it doesn't. So certainly within JISC, I think we're planning to treat this as a subject access request with the data being provided in a digital format. The regulators have produced final guidance on this one. They've taken the phrase about industry standard digital structured format, and they've said CSV, and said, well, actually there aren't any industry standard digital formats with more structure, better defined than that. So I think their expectations are shrinking rapidly as they hit reality on that one. Automated decision making, the second of those sub-bullets was added last week when I read the regulator's draft guidance. I read the text of the law as saying that if an fully automated decision is made about you have the right to say, please have a human review that, which seemed useful, proportionate, quite a good thing to do. The regulators have just published a draft which takes exactly the same text and says, no, this bans automated decision making for any decision that has legal or similarly significant consequences, is the phrase, and they refuse to define that. So I'm really, really hoping we can fix that draft, because it's ugly in its current state. Keep an eye on the blog for news on that one, because they need responses by the end of November, or by the 28th, so there will be a response going up there on my blog. There's then 3 rights relating to sort of errors in processing, things like that. Right to rectification, so if a subject access request or anything else reveals that the data you have is incorrect, you have a right to correct it. Hey, wow, wonderful. There's a right to erasure, not as wide a right as it has been portrayed. This is only about when there's no lawful basis left for processing. So if somebody's processed data based on consent, if they've withdrawn their consent, you no longer have a lawful basis and you need to delete it. Similarly, if it's necessary for this contract, the contract is finished, you're beyond the point where it could be challenged, no right anymore. Yes, Matthew, thanks for putting that one in the lower box. I'll come back to it later. Right of objection, again, depending on the legal basis for processing. If you are processing on legitimate interests or public interests, both of those have a sort of a balancing test where you're required to look at the benefits of the processing and the risk to individuals. So you're going to do the risks on some sort of averaging basis. And the right to objection is basically an individual can come and say, I don't believe I'm average, please will you redo the balance based on my particular situation, and assess their rights and interest. You can conclude that the balance still favours the processing. Objection isn't a you must stop, it's a please look at my particular circumstances. And for any of these three, while you're thinking about it, there's a right to restrict processing. So an individual can say, I have asked you to correct the data, I've asked you to raise it, I've raised an objection to your processing. While you're doing that, only process it for the purpose of exercising those rights. Stop processing it as you otherwise would. Security, there's still the same statement as in the existing directive, that you must use appropriate organizational technical measures to protect security of data. Much more detail here. The GDPR text itself mentions encryption, pseudonyms, authorization. It even mentions incident response exercises. Wow. Explicitly, again, these should be risk-based. So if it's low risk data, you're not expected to apply the same weight of technical measures as if you're handling health data and so on. But you do need to keep an eye on technology, both in terms of technology of causing breaches and technology that's available to prevent them. Sorry. And then this plays back into data protection design. This shouldn't be added on. This should be done as part of the design. Oops, sorry, I have to click on that one. Significant change. There is a requirement if a security breach occurs, and security breach is widely defined. That lot is the definition in the regulation. The draft guidance the regulators have just put out also adds things like denial of service attacks where those attacks affect the rights of individuals. And the example I give may be related to a UK incident a few months back where they say a denial of service attack that causes appointments for surgery, so health processes, to be cancelled clearly affects the rights of individuals, so that is a reportable breach. And the threshold, if there is a risk to the rights of, three kinds of breaches are recognised. Ones that don't involve a risk to the rights and freedoms of the individual, those ones you need to record. If there is a risk to the rights and freedoms of individuals, you need to inform the regulator within 72 hours of learning of the breach or becoming aware. And the guidance that they put out last week puts a pretty challenging definition of becoming aware. You can't, if you get a report of something seems to have gone wrong, you've got to be pretty quick at investigating to find out what happened. And if it's a high risk, and they quote things like bank card details, then you also need to inform individuals. The guidance now makes it explicit that in many cases you can seek the regulator's view first. If it's bank card details, if you have, if you've lost credit card details, it's obvious what's happened, it's obvious what the risk is. I think you'll be expected to say to people, contact your bank now, or contact the bank to get the cards cancelled and so on. And there is very positive support, fortunately, since this lot means you need to do incident security and incident response really well. There's positive support for that. So, some of the practical way. There's some practical stuff in there, but information life cycles, we've done security and user rights, a bit more on the legal basis for processing, and given this is an international audience, I put in localization as well, which I think may be an issue if we're developing systems. Miro, should notification to users be personalized? Not if it's too much effort. There is an explicit recognition that in some cases that may be too hard, in which case you are supposed to do a public notice. So you need to do one or the other, either an individual notification or public notice, and the public notice has to be in places that your users will see it. You can't hide it away at the bottom of page 10. So, information life cycles, said most of this, but understanding what we're doing when we're collecting data, why, how, who from, when we're processing it, why, how we're protecting it, any transfers to partner organizations, any disclosures to things like law enforcement. I'm trying to distinguish between those, that a transfer, there is continuing responsibility disclosure. Once I've disclosed to the police, I'm no longer responsible for what they do with it, provided I've done the disclosure lawfully. And remembering that deletion is as much processing as anything else. I was in a meeting yesterday where the idea of having to think about retention times was quite startling. So I'm kind of thinking about this as how information flows around in time, but also in sort of logical space. Where does it go in organizations, in systems, and so on? One advantage of this kind of understanding of your data, I think, is if you look at any quality information security standards, you'll find you need to know very much the same thing. So even if you're not looking formally at those standards, I think doing this sort of life cycle analysis will be helpful for your use of information. We've certainly found it so. Something that's not formal in the life cycle, but it seems to me this would be a good point to think about. What are the risks to the information? How do we secure it? And what's going to happen if there's a breach? If you're thinking about what the data is, how serious a breach is this going to be? Is this going to be a reportable to regulator? Is this going to be a reportable to individuals? And get your notices prepared. Try not to let them leak. That's embarrassing when you allow somebody to find the website that says your data has been compromised when in fact it hasn't. Legal bases. The 5 that I look at first all contain the word necessary. So necessary for a contract, and certainly in English and derived laws, contracts do not have to be signed and in writing. Contracts are any agreement between parties which they expect to have legal effect. So using a website, there's a contract to provide the information necessary to serve the page that you want. I'll come to an example in a minute. Necessary for law, so if the law says you must do this, then you have a legal basis for processing. Necessary for life, vital interest is the phrase that's actually used. So is somebody going to die if I don't do this processing? I guess we haven't quite got there within JISC, but I'm guessing the next of kin to be notified if you collapse in the office probably fits under vital interest of the individual, because you're not going to be in a position to give consent to tell your next of kin that you need to be taken to hospital. Public interest is very ill-defined, so until somebody can actually define it, I really don't want to rely on that one. And the other one that I think we're going to use quite a lot, we already use in federated access management, is legitimate interest. That one is interesting because unlike all the others merely say, is this necessary for the purpose? Legitimate interest says, is it necessary, and is the benefit that is gained from it does the benefit that is gained from it justify the risk to individuals? So there's an additional balancing test that you have to do. If your processing isn't necessary, then there is consent. And I'm increasingly tending to the view that consent is only valid if I can lie and the system won't break. so information that's not actually necessary for either party, where leaving a field blank, stuff still works. And I've mentioned that there are different duties, rights, and notice requirements for each. A lot of our processing's complicated, so you may end up with more than one justification. So if you wanted to sign up to this webinar, can I do this one on the fly? We needed to know your email address so we could let you know where the webinar was. So that's a can't provide service without it, which is contract. We also keep an eye on IP addresses of people visiting the website, because there are some interesting patterns there for securing the website. That's a legitimate interest. We have to do a balancing test to say what risk are we creating by storing that data? Does the need to protect the website justify that risk? By and large, yes. And then there's consent. You have all helpfully typed in, actually you've typed in quite an interesting selection of different forms of your names here, which to my mind demonstrates that the name you are typing in there is by consent. If any of you wanted to type in Harry Potter, the system would work just fine. I might not recognize which of you it was that had done that, but there are some real names in there. Some people have told me they're institutions, some people have just given initials. That looks like a classic consent to me. One that we may hit in international projects, not part of the law, but the law just says in Europe, good, out of Europe, bad. Some countries have twitchiness about other countries. Apologies to those in the US. A lot of people have twitchiness about the US. A lot of people have twitchiness about other countries around. But even within Europe, some people say, no, I want this to be in my country. So if you're designing a system, I would have a think, can we meet those requirements? Does it make sense to have or to offer per country directories, per country service options? Is it possible to store data in multiple locations but bring it all together? Sorry, not bring it all together, bring the necessary stuff together at the moment of use. Those might scratch some itches that are coming up. If you've designed it in, or at least if you've not designed it out, if you thought how we do it, you can then tell people how much it will cost if they ask for it. And it seems reasonably clear to me that it mostly will cost something, but at least you've got okay, this is how much it costs. Is it worth that to you? Right, 3 examples. We're a little over time, but we'll get there. Federated access management. Really good news. I think GDPR is pretty much entirely positive for federated access management, because at least as done within research and education federations. Data minimization we have been doing since we started. We do attributes, we don't exchange names unless they're needed, we exchange email addresses only when required, stuff like that. Most things are done using pseudonyms. That's a huge tick in GDPR terms. The stuff that is actually needed to make services work. So another point on that, and if you're asked about this, this is my starting point. The alternative is to use Google, who do not do data minimization. Their whole business model is about not doing data minimization. So we have a really good story to tell here. Stuff that is necessary, we've concluded that the simplest way that doesn't need a great mesh of agreements and understandings and other protocols is to say that it's in the legitimate interest of a service provider to provide the service they've been asked, of an identity provider to provide the authentication service that they have been asked to provide by the individual. So that avoids having to get into communications between the service provider and the IDP saying, was the user free to give consent? Don't go there, just stick with legitimate interest in my mind. Means you need to do that additional balancing test, but I think most applications should pass that with ease. If they don't, I suspect you'll struggle to get valid consent anyway. Yeah, sorry, I will. Philippe's is a for later question. It was short enough, I thought it might be an in-course, but it isn't. The other win here is that under the directive, you couldn't use legitimate interest as a basis for exporting personal data from European Union. Under the regulation, you can, as long as they are, I've phrased it as ad hoc. I got the actual wording is something like small scale and not routine, which to me looks like a good fit for request response that goes on in access management. There is a little wrinkle here in that right down at the bottom of that section it says, and you need to inform your regulator. I'm hoping that regulators ignore that. Or that regulators say, okay, tell us once that you're doing it. If regulators say you need to inform them every time you export an attribute, I think they will collapse quicker than we do. We could automate that end if needed, and we could DDoS any national regulator. So let's be sensible and not go there. If you've got data that aren't necessary, so as I say, this is a good example, this one, the names that you typed into the box, not necessary data, consent. Works a treat, because you can put, oh, I've got 2 Chris R's, I wonder if they're the same person. Security and incident response, I say there's the GDPR, there is a recital that specifically says security and incident response is may be a legitimate interest of quite a wide range of organisations. And there is this Breyer case, European Court of Justice, which effectively backdates that to the current directive as well. I can't see how you can do breach notification without good security and incident response, and the guidelines, draft guidelines published last week, made that explicit. They actually threaten, if you think we take too long, yes, Matthew, you did explicitly consent to your names by just entering them. We may not have actually said that this would be displayed to everybody else in the conference, but hey, it's not the 25th of May 2018 yet. No idea whether we can get Adobe to work on that. So yeah, the guidance on notification explicitly threatens if they feel you took too long to notice a breach, then they may well come in looking to say, were you in breach of Principle 7? So the requirement to apply appropriate technical organisational processes. Having gone to legitimate interests, that provides, it's the most analysed of the bases, and what there is in there, there is a 10,000 word, no, it's a bit less, 9,500 word peer-reviewed law paper there explaining why and how most current incident response practice fits really nicely into that. We do this, the sorts of balancing that we're required to anyway. So big plus for that. Location data, just to highlight some of the still uncertainties, indeed contradictions. Under the GDPR, location data doesn't have any special treatment. So if I'm a cell site, I can say I need to know the location of the user so I know which cell site to connect their mobile phone through. I could say, find my iPhone, really useful value-added service, necessary for the service, necessary for contract, get on with it. I could perhaps say necessary for the public interest, trace the bad guy through his mobile phone, or consent. These are actually wider than what's allowed under the current e-privacy directive. Somebody noticed, so the e-privacy regulation, as I say, wanted to say only necessary for consent, sorry, only necessary for service or consent, which, because consent has to be positive, means you can only do it for connected users, as far as I can see. But you then read on and you start thinking, wait a minute, these regulators really like those signs at airports that say only 5 minutes to get through security now. And those are largely run by keeping an eye on Bluetooth and Wi-Fi broadcast from not connected mobile phones. So it's almost funny watching them try and explain why those sorts of applications really should be allowed because they're really useful, even though they sort of break the fundamental principles that they want to have for the privacy regulation. That one's going to run, and run, we'll see where we get to. So I think that's my slides done. There are a load of references. The slides will be published along with the recording, so feel free to have a look through those. I think I will now go, if I go back to the questions box. Right, processes. Okay, Matthew. Audit logs of login attempts to AD, I would go for security. So anything that is not actually necessary to provide the service. So your easy proxy processing the login data and making the connection is necessary to provide the service. Your records of what has happened are to protect the security of the service or the interest of the rights holder or whatever. That's legitimate interests. I wouldn't even start thinking about contract for that one, which means you need to do the balancing test. If you do that, and I think the login attempt one is analysed in the paper. If it isn't, there's something quite close. I think you'll discover that what the law requires for data protection, because you're protecting personal data, is what you already do to protect because logs are security sensitive. So that's where I'd go with those. I don't think it's necessary for the purpose of the contract. It's necessary for the security interest of both. And you can process for the legitimate interest of a third party. Chris... not sure I follow that one. If you're thinking of terms of use as a privacy notices are one of the things that guidance, we're sadly lacking guidance on, and I don't actually expect it till well into next year yet now. What you can do, and what we have done, is to take what the GDPR itself says need to be in the privacy notice, and because it might have to change, we've said there will be a single copy of that which all JISC services have to link to, and they should make clear which parts of that notice apply, but only not copy the notice. Please don't copy the notice. So if we have to change anything, we can do it centrally. Employees and students, I suspect, are different. Certainly in our terms as an NREN provider, customers and employees are very different. I'm planning to use the same approach for employee data, but it will be a different privacy notice, notably because I don't think there's any legal requirement on us that relates to customer data. All of that has to be done under either necessary for, necessary for to provide the service, a necessary contract, legitimate interests in security and improvement, or consent, is the other one. I don't think we can claim any of that processing is necessary for legal obligation. I'd struggle to find anything that's necessary for vital interests. For employee data, I suspect we'll have quite a lot of legal obligations, and we may have a little vital interest one as well. And we probably need to look carefully with employees where we're using legitimate interests, because the risk to employee might be higher. Also consent, I think there will be a presumption that consent by the employee is invalid. We may be able to produce evidence that the consent was actually valid. They were genuinely free. We have a staff survey that is anonymized. I think we can argue consent on that one. So yeah, there's certainly a difference there between employees and students. Well, maybe less of a difference actually between employees and students, because they're both people who are in quite a dependent relationship on the organisation. So you need to look carefully at the balancing test on legitimate interests and at whether consent can actually be freely given. There is a paper which probably isn't referenced there, but if you drop me an email, on how this works for big data, which does get a bit more into employee data. Philippe, look at IP addresses to internally discuss the geographical success of the webinar. That's a damn good idea. I hope we can do that by knocking off at least the last octet, which is, if you've only got the IP address, I would hope we could reduce that sufficiently to a level that it would reasonably count as anonymized. And I hope we would do it that way. So it's a problem but I hope there's a solution to it. Right to erasure. Yeah, the right to erasure, Janosch, applies if you have no legal basis for processing. And they take about a page to say that, because they list all the ways that you might not have a legal basis. So logs are federated and federated T and I. As far as I know, certainly in the UK, our recommendation, you're keeping logs of access for security. We want to be able to deal with security problems certainly within 6 months. Otherwise, goodness knows what damage has been done. And educating the user isn't going to be much effect if we wait as long as 6 months. So our recommendation within the UK is that you should keep those logs for between 3 and 6 months. Some universities keep it for a year because that's their natural cycle. Fine, if all the rest of their systems work 12 months on, I'm not going to insist on them killing off their authentication logs, which will mess up various other data. If they've come up with an argument that the 12 months is reasonable, fine. Repositories of publications, I'm not sure where you're at with that one. There've been a couple of slightly tricky ones where individual is named in a paper or in a news article or something, and individual has said, stop publishing that. I've still got a legal basis. If I'm publishing, if it's in the legitimate interest of science, so knowledge, whatever, to continue publishing the paper, I have a legitimate interest. So the most they have there is a right to object, not a right to erasure. And this gets you back into the Google Spain case, which I think was horrible. It's another one that has consequences way beyond the original case. But the idea there was that newspaper articles, the newspaper had a legitimate interest in publishing them, but could maybe restrict publication of information that was 10, 15 years out of date, where in that case it was, I think the guy had been declared bankrupt. However, there are now cases the other way where a convicted criminal has said, delete the news or block access to the newspaper archive. That discusses my case. And the data protection lawyers, the data protection courts have said, well, if you've got a national I know a statute of limitations is the US term, but a period of time after which your conviction is considered not to exist anymore, certainly you have a right to erasure after that, but up till that point, your conviction is a matter of public record, particularly if it's conviction for something that's of public interest. If you're a public figure who's been convicted of fraud or something, I think they would consider that to be strongly in the public interest. So it's, again, the balancing test. It's not an absolute right to erasure. So, hope that... I think am I at the bottom of the box, or do I need to scroll down more? Oh, sorry, Chris. Oh, there are more. Chris, too long to notice a breach is going to be tough. I don't think a responsible disclosure practice is a breach. If you know about a vulnerability as a data controller, try and put mitigations in yourself. I'd be surprised if there's a genuine 0 day. If any regulator, if there's a 0 day, you get hacked on day 0, you report on day 3. I would hope that regulators will go, good person, you've got effective processes for patching. Now, if you report that you weren't breached because you patched, even better. Can I say federated AI is ad hoc release afterwards? I think so. The release only happens when an individual says, I want to go and use that service. Where there might be problems is we've had some queries from universities who have a course that is run in the US. And there I think you probably do need a contract rather than treating it as ad hoc. Not going to respond to Edward in blue. And yeah, well, Chris, yes, I am aware of how long vulnerabilities take to be disclosed, and the fact that many of them are disclosed. Sorry, and that fixing the vulnerabilities may take even longer. But I don't think I'll make a note to look in the guidance whether it actually covers that one. But that guidance shows enough clue and enough understanding of the world that I wouldn't be, well, I'd be concerned about that one, but not from a data protection point of view. So I think we're agreeing on that. And we have a query from the University of Vienna. I can hang around for a few minutes more. I think I have a taxi at 20 past. Just opening my diary to check. So I think we're done for the point of view of the webinar. Thanks, I should say, to all of you for attending. Thanks to Edward for local support. Okay, what about cloud? No idea. And I don't think the regulators have any idea about cloud either. Why didn't that one update on my screen? I think the regulation just about understands software as a service. I think it is utterly clueless on infrastructure as a service. I don't think there's any recognition of what's going on there at all. I don't think they even know where to put Amazon EC3 into the framework. There are various activities going on to try and set up industry codes of conduct. However, one of them submitted, I think it was the software as a service one, they submitted their proposed code to the Article 29s. They got feedback, and they are now declaring that they have addressed the feedback, but they don't seem to be sending it back to the Article 29s. So I suspect there isn't going to be a formally approved code of conduct for cloud. I would, as far as possible, look at where your cloud is, look at what the data are that you're putting in, and try and come up with a story as to why this isn't an unacceptable risk to your users. And I know that's very weak and very thin, but I'm afraid that's where we are with the guidance. The user's right to expect you to propagate their wish of being deleted. That's the Facebook one. I mean, as Federation operators, I think the only thing we're going to be deleting is log files. And those aren't information. The right to be a further notification only applies where you have passed on the data to others. So I don't think that one's going to apply. It seems mostly to be addressed to social networks and things. Okay, SAML 2, sorry, you're beyond my technology. If you can drop me an email, my email address is easily findable, or indeed go on, Edward, type it, andrew.cormack@jisc.ac.uk. I would hope that if you have a process or a protocol for passing on data other than when the individual wants it to be passed on, then you also have a built-in process for deleting that data at the far end. Simply throwing out data with no conditions for the recipient is kind of dodgy. Not just because of there isn't really a term for that I've seen, but the passing on of the right to erasure. So I'm hoping we're not doing anything that comes within the scope of what they want us to do there, or what they want us to not do. And I didn't say thanks to Leacher for the invitation to do this and for setting it up, and to IAMOnline for the promotion and doing the admin and stuff. So
the best source I just yeah, sorry, thanks a lot, Andrew. Yeah, I guess that wraps us up and brings us to the end of the webinar. Sorry we ran a bit over, but hopefully that will give you a good amount of time for those extra questions to come in. But if it's inconvenience you slightly running over, so apologies for that. But I do hope you found it beneficial and it kind of met your objectives for being here and informed you a lot about this very important subject. So yeah, thanks ever so much to Andrew for presenting, and that brings us to the end of the webinar. We're going to share the link to the recording shortly afterwards, and you can download the slides. You can see the IAMOnline YouTube link on the references slide there. That's where the recording will be made available, but I'm sure Lichia will send out an email containing that as well for you. So yeah, all you need to do to leave the session is close your tab or window, browser window that you've got the session running in, and that automatically logs you out. Again, just thanks again to Andrew, and thanks a lot for being here. Okay, cheers, bye-bye.